William Silla is our sign language interpreter tonight. Welcome to the program. Let's start off at the African Union that has tonight adopted a proposal by President Uhuru Kenyatta to develop a roadmap for withdrawal from the Rome Statute, the treaty that established the International Criminal Court. The AU adopted the proposal without any amendments. Uhuru, in his appeal to the 26th AU summit in Addis to back his proposal, also asked the continental bloc to insist on the termination of the case against his deputy William Ruto at the ICC, arguing that the Hague-based court was pursuing weak and politicized cases.
It's an honor to welcome you to this 26th.
As the 26th African Union Summit in Addis Ababa came to a close, Kenya was taking yet another shot in the quest to have African nations disengage from the International Criminal Court. And this time, President Uhuru Kenyatta was leading the crusade, following a report by a committee set up during the 25th AU Summit in Johannesburg, South Africa in June last year to look into Africa's engagement with the ICC.
In the face of mutating global terrorist threat that is costing us lives and great economic loss in the midst of playing our part in mediating multiple peace processes in our region, we have had to contend with an ICC pursuing weak politicized cases. This has become a huge distraction from our duty to serve our people and this continent fully.
Uhuru, whose crimes against humanity charges at the ICC were terminated in March last year, told the summit that the ICC has not lived up to the expectations of countries which signed up to the Rome Statute seeking to combat impunity.
That is not what Kenya signed up for when we joined the ICC. I highly doubt that those of you that are its members expected this to be the way the court would conduct itself.
He asked the AU to come up with a schedule for the withdrawal of African nations from the Rome Statute.
We will not and must not tire in this effort to reform the ICC. I therefore urge you to adopt the resolutions of the Ministerial Committee on ICC and include a new mandate to develop a roadmap for withdrawal from the Rome Statute as necessary.
The Rome Statute, the treaty which established the ICC, was adopted in the year 1998 and came into force in 2002. 123 countries are state parties to the Rome Statute. 34 of them are African states. At the AU summit, President Uhuru Kenyatta also asked the continental body to rally behind his deputy William Ruto, who is facing crimes against humanity charges before the ICC.
We must reaffirm that the global standard for impunity for heads of state should also apply to Africa and insist on the termination of the collapse cases against the Deputy President of Kenya.
It is not the first time that the African Union is taking on the ICC matter. In October 2013, the AU called for the deferral of cases against sitting heads of state and government until they leave office. In February 2014, the AU made the same proposal, and in September last year, the Union tried a different strategy when it pushed to have the United Nations Security Council put the deferral issue on its agenda during the 70th session of the UN General Assembly meeting in New York. The 54-member continental bloc adopted President Uhuru Kenyatta's proposal for withdrawing from the Rome Statute without any amendments. But that may be as easy as it gets. Withdrawing from the Rome Statute will no doubt be a lengthy and complex affair. Rita Tinina, KTN News.
Meanwhile, is there a change of plan for the AU in Burundi? There is an indication that the African Union could be changing its mind on sending a peacekeeping force to Burundi. Now, the AU's special representative for the region is reportedly saying that the African Union will not deploy peacekeepers to the troubled Burundi country unless the government in Bujumbura agrees. Burundi has consistently opposed the idea of the AU's proposed 5,000-strong peacekeeping mission, saying the deployment of troops without its express permission would be tantamount to, quote-unquote, an invasion force. Let's now switch gears and come back to the country and to the corruption claims against the judiciary. And leader of majority in the National Assembly, Aden Duale, is now asking Chief Justice Willy Mutunga to resign. Duale says, as the head of the judiciary, Mutunga should bear responsibility over the state of the judiciary. And as Zinzi Kibiku now reports, this comes as Justice Philip Tunoi, who is at the center of the latest graft claims against the judiciary, is set to appear before the JSC tomorrow.
Kenya's Supreme Court has been shaken over the bribery scandal on Justice Philip Tunoi's alleged 200 million Kenyan shillings bribe from Nairobi Governor Yvonne Okwara. And in Garissa, Majority Leader in the National Assembly Aden Duale wasn't mincing his words.
Yeye mwenyewe anasema Wakenya wakikuja kutafuta haki lazima wanunue. Tunaambia nyumba ikiharibika lazima baba ajiuzulu.
The claims against Justice Philip Tunoi's integrity have raised concerns about the leadership at the country's top court.
I've never met Kidero physically. I've not even greeted his hand. I'm sure he must have seen me in court or anywhere, but I've never been close to him. I've never spoken to him.
The Commission will handle this matter with utmost fairness, independence and fidelity to the Constitution.
Recently, Duale has engaged in a bitter exchange with Mtunga, both accusing each other's institutions of corruption.
Mkubwa ya mahakama ni Willy Mtunga. Yeye alisema kwake nyumbani judges yake ya Supreme Court akiwa yeye president, judges wengine paka magistrates, ufisadi na ukora imezidi. Tunakuambia wewe kwanza ndio umeharibu kazi, ulikubali ufisadi endelee, umeshindwa kazi, wewe ujiuzulu, alafu tutoe wale wakora wako katika mahakama ili tusafishe hiyo mahakama.
And as for Philip Tunoi, who claims he has never given or received a bribe as a public servant or a judge, he will issue his affidavit before the Judicial Service Commission on Monday. Zinzi Kibiku, KTN News.
Graft within the judiciary. But how did we get here? Once upon a time in Kenya's history, we made attempts at reforming the judiciary. So let me take you down that path for just a moment. Back in 2003, we had what was called radical surgery of the judiciary. It was steered by Justice Aaron Ringera. Now, during that time, 23 out of 45 Court of Appeal and High Court judges, as well as 82 out of 254 magistrates, were found unfit to serve. Now, some of them were implicated in corruption, many retired, and others fought their way back into the judiciary through court cases. Many years later, in 2011, the Judges and Magistrates Vetting Board came together, was led by Justice Sharad Rao. During this one, 13 judges were found unfit to serve. And remember, this is an ongoing process. Some ended up being cleared by the Commission. We then went on to set up an Office of the Ombudsman within the legal fraternity, whose job it is primarily to receive complaints from members of the public and respond to them about the conduct of judicial staff. Now, in its first 3 months of work, 700 complaints were received, and some say, well, it's also taking a look at the capacity of this office to be able to do that. But at least efforts were made. Did you also know that there's an online system and you can send inquiries to the number 5834? This is how far we came with judicial reforms, and we thought we were on the right track. Then we started to hear allegations, that of Tunoi, and finally this that came out of the Chief Justice himself in a newspaper interview abroad. He talked about Kenya being run by bandits, essentially being a bandit economy. Locally, I want you to listen to what he had to say just last week. Some very damning allegations coming from the head of the Supreme Court of Kenya. Listen to this.
It causes me a lot of pain that an election involving judges and magistrates will be corrupt. Because can you imagine a judge bribing another judge so that they can vote?
So he's talking about corruption between judges who want to make or get a seat on the JSC. Then, of course, we remember those allegations against Supreme Court Justice Tunoi. Now, this brings us to an interesting point, and some call it judicial incest. Now, I want to just paint this conundrum for you. We're calling it Conundrum number 1. First, before we get there, you need to understand the membership of the JSC. At the head is the Chief Justice. We have a representative from the Supreme Supreme Court, that is Justice Smokin Wanjala. Mohamed Rasame representing the Court of Appeal. Agri Muchelule representing the High Court. Tom Ojienda together with Florence Mwangangia, the two representatives that come from the Law Society of Kenya. You of course have the Attorney General, you have Professor Kobia who's representing the Public Service Commission, and these two individuals representing members of the public. Now, let's just stay here for a moment because this is where we come to conundrum number one. Now, we know that the Chief Justice put together a subcommittee of the JSC to look into the allegations of Justice Philip Tunoi and that he received a bribe of $2 million US. Please note, corruption now is not alleged in Kenyan shillings but is in dollars. But this is where we have an issue. So that subcommittee is going to present its full report in 7 days to the full committee. Now, there's a number of members here who have a conflict of interest. We will start with Tom Ojienda, who represented Evans Kidero in that court case. And remember, Evans Kidero is said to be the giver of that case. The other conundrum, there's other interested parties. One of them is Mohamed Wasame. He sat in the Court of Appeal that heard the petition from Waititu on the lower court and ruled that Kidero was not validly elected. So you can see there's already a number of members there, including Smokin Wanjala, who sat in the court of the Supreme Court hearing on Kidero's case. So already a conflict of interest. Here is conundrum number two, and this has something to do with the succession cases that we've heard might be at the center of all these corruption allegations. You know, Kalpana Rawal and Tunoi have gone to court seeking to have their retirement at the age of 74 and not 70. Now, they have been allowed their day at the Court of Appeal. But let's just say hypothetically that this case goes to the Supreme Court. Remember, for the Supreme Court to be fully constituted, it needs 5 members on the bench. Okay? Now, here is where we have a problem. 2 of those members are petitioners. That's Justice Kalpana Rawal and Justice Tunoi. 2 others are in the JSC, which itself is a petitioner in this case and has a stake to play. Only 3 would have no direct interest in the matter. And some say, like Okoiti Omtata, that all the other 3 do have a stake. Why? Because this affects their possible retirement age when they get to the age of 70. So where are we now with the state of the judiciary? When you have such damning claims and when you have all of this confusion, not to mention even the membership itself of the JSC, when you have certain members of the LSK represented there but still presenting cases before these very judges that they vetted. Where are we now when we have all of these allegations touching the highest level of the court in the land? This is what we'll be discussing on Checkpoint. My guests are here with us. We have Elisha Ongoya. We also have Edwin Sifuna, as well as Apollo Mboya, who's the outgoing CEO of the LSK. Please feel free to send us your feedback. Where do we go from here? My guests are already in studio and waiting for that discussion. The hashtag to use tonight is Checkpoint. I look forward to hearing from you on that.